Appeals meeting to order. It's Thursday, May 1st, 2025 at 7:49 p.m. We'll begin with roll call.
Ms. Fryer?
Here.
Mr. May?
Here.
Mr. Ballard?
Here.
Ms. Zielinski? Here. Ms. Rude?
Here. I will also note that Pam Zielinski is an alternate that will be in full voting privileges mode this evening. Thank you for being here with us. Appreciate you filling that spot for us. Public notice read as the ZBA will meet at the Town of Boston Town Hall on Thursday, May 1st, 2025 at 7 p.m. for the work session in the planning board room, followed by the public hearing in the courtroom to hear the following petitions. Open petition number 634, New York Boston 2 LLC, Buffalo Solar Project at 7832 Feddick Road, seeking 3 area variances, 384 feet for the south side, 375 feet for the north side, and 23.8 acre variance for a new proposed solar array. Petition number 635 is Horseshoe Hill LLC, 7588 Lower East Hill Road, seeking several area variances for setbacks. Area variance of 17.14 feet for a side yard setback of an existing metal building, an area variance of 88 feet and 2 feet for side yard setback of the manure building, area variances of 30.6 feet and 72.21 feet for side yard setback of the stable building. We're going to start with our Pledge of Allegiance.
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We already have an open public hearing, so we're going to continue on with that for petition number 634. I have some information to be read into the minutes. From Susan Sandy, 5055 Mayor Road in Hamburg. We respectfully ask that you do not approve petition number 634, grant any variances, or approve the solar project of 7832 Feddick Road. The local community has displayed extreme opposition, have given many examples of environmental impact, agricultural preservation, and have suggested alternatives, making the variance unnecessary. Approving a variance undermines the zoning's purpose, protecting agriculture and land, and sets precedent for future erosion of farmland. The land has irreplaceable value for agriculture and preservation, much more than a temporary solar installation. Zoning laws are a powerful tool for land preservation, but their effectiveness depends on how rigorously they're upheld. Please stick to the zoning's intent and do not bend it for short-term gains. From Eric and Nikki Gowron. This is Eric Gowron, and I live at 7919 Feddick Road, Boston. I'm writing to vehemently oppose the solar project at 7832 Feddick Road. This is happening in every rural town, and pretty much the residents of those towns are constantly against the solar farms. Yet the towns usually approve them. We seriously need to stop this madness. We live in a farming country community, and it needs to stay that way. Personally, farmland should stay farmland. If the owner isn't a farmer, they can lease it to another farm close by. Or here's a thought, let nature take its course and let the plants and trees grow for wildlife. Now I understand we need a tax base and that requires development and residents. So if some land gets developed into some homes, that's okay too, as long as the lots are large enough to maintain a country feel. Personally, I think a minimum of 5 to 7 acres, but the absolute last thing that should be considered is solar farms. Even they're off the road and out of sight, I don't want them in my community. It's been proven, regardless of what these scam artist salespeople from the solar companies say, that solar isn't as effective as you may think. Just like wind isn't that effective, especially when you factor in the cost of actually putting it in, combined with the loss of nature. But these companies find people with land, throw a bunch of money at them, and we get into this situation. It's just greedy companies and even greedier residents causing this problem. The owner of this property should be absolutely ashamed and embarrassed of what they're trying to do. There are so many possibilities for land, and they've chosen the least favorable for a money grab. It's quite sad, actually. To the board, please do what's right and stop this from happening. Keep Boston the beautiful town that it is, and keep your residents happy. Don't let greed prevail. From Larry Stiller. Attached are comments for zoning board meeting in reference to open petition number 634. Please make these comments available to all board members as well as the meeting attendees so they can see the comments and photos as they are presented at the meeting. And he sent a whole bunch of copies of Altius Vista LLC, solar farm discussion points and safety concerns. I don't know if it was from a PowerPoint, dealing with water runoff and retention with photos, fire protection, surrounding climate effect, unattractive long-term economic value, decrease in housing and property values around solar farms, severe weather risk, solar panels, additional weather information with drone footage picture, and tornado damage of the summer of last year in North Boston with tree damage on Zimmerman and Keller and Fedek roads. And he has questions that he would like answered. If severe weather such as a tornado, strong winds, heavy hailstorms impacts the proposed solar farm on Fedek Road, deposit solar panel debris on neighboring farmland, who's going to clean it up? Damaged solar panel debris is a Resource Conservation Recovery Act classified as hazardous waste and must be disposed in a secure chemical landfill by trained, fully clothed protective personnel. Is there an approved plan in place by whom to implement a proper cleanup procedure? Does it include names and addresses of personnel who are going to perform it? And is it updated annually? Who will verify that the land is suitable for farming to produce food for human and animal consumption after the cleanup? Will the soil be sampled and analyzed for residual contamination, and by whom? Are sufficient funds available for the protected life of the solar farm to pay for debris cleanup and to compensate local farmers, including relocation should the land become unusable after contamination? And also about long-term health concerns, lack of studies proving there are no potential long-term health risks for individuals living near solar farms if these farms are supposedly capable of producing high megawatts of power. So if anybody wants to read that, he asked me to share it. There it is. All right, from Mark Belanger, probably crucifying that name. The ZBA, the ZBA's prior approval of a 16-acre first phase solar array on the entire 72-acre tax parcel appears to be in conflict with local law number 4, which limits the large-scale solar energy system site to 50 acres of total land area. Under the code, the site's defined as all land leased, owned, or otherwise controlled for the solar project, not merely the fence panel, its footprint, because the developer has maintained control of a full 72 acres. The legally relevant site area already exceeds the 50-acre cap, unless the board, A, first required a subdivision that carved out a less than 50-acre lot for the array, or B, formally granted an acreage variance after applying the 5-factor test in town law 267B. The 16-acre approval was ultra vires beyond the board's lawful authority. Requested action, confirm the record, provide the public with any subdivision plat or written acreage variance resolution that would bring the prior approval into conformity. If no such documents exist, acknowledge that the initial approval was non-compliant. Rectify before expanding. The board shall not entertain the current request to enlarge the solar footprint or issue a new 23.8 area variance until the legality of the first approval is resolved. If the earlier action violated the code, the board must rescind or amend it to comply with the 50-acre limit rather than compound the error. Place this letter in the public file for petition number 634 and read it into the record at the next CBA meeting. Failure to address this defect exposes the town to an Article 78 challenge for acting contrary to its zoning law and New York Town Law 267-B. I trust the board will review the matter promptly and ensure that any solar approvals strictly adhere to the acreage cap enacted to protect Boston's rural character. Thank you for your attention. So Dwight is our counsel that has been specially procured by the town for us for the solar farm application. So what do you think of that story?
I guess I'd have to read that one closely and review your live.
Okay. We will do that. That's Andy wrote another one. Thank you for the opportunity to comment. It's basically the same thing, 6 days prior. His opposition is based on the following points: violation of town code. Number 2, contrary to the comprehensive plan. Number 3, ZBA's legal duty. Number 4, dangerous precedent and legal rights to the town. And in conclusion, the zoning board's role is to grant relief only in exceptional cases where a variance truly satisfies the legal criteria and uploads the spirit of the zoning code. Here, the requested expansion of the Fedek Road solar project to around 72 acres starkly violates the letter and spirit of our town's law. It conflicts with the 50-acre limit established by local law 4 of 2019, and it flies in the face of our comprehensive plan's mandate to preserve rural character. Approving this would not be a harmless accommodation. It would be a grave error, setting a harmful precedent and undermining our community's confidence in its laws. I respectfully urge the ZBA to deny the 23.8-acre area variance and any other variances that violate our zoning dimensional restrictions. By doing so, you will protect the town of Boston's rural character, uphold the rule of law, and reinforce that large-scale solar developers must follow the same code that everyone else does. Thank you for considering these comments, and please vote to protect our town by rejecting this overreaching proposal. Mark Bellinger. And that one to his election. This is that. All right. Is that everything I did? It is. All right. That's all the reading I have for this one. So, you may step up to the microphone if you have something to say that has not been heard before, as in last month, stating your name and your address.
Good evening, Chairperson Rude, members of the ZBA. My name is Stephen Bailey. My business address is 6 North Main Street, 200J in Fairport, New York. I'm with the law firm Citizen Environmental Law, and I'm presenting tonight on behalf of the citizens of Fedek Road. Schoolyard bullies. Schoolyard bullies look like they're in charge. They might look taller, they might have big muscles, they might puff out their chest to look like they're the ones in control. They might tell you they might tell you, give me your lunch money. They might say, that's my seat on the bus. But schoolyard bullies don't make the rules. They are not the boss. Right now, in this proceeding, at least before this board, Delaware River Solar is acting like a schoolyard bully. They're saying, we're a public utility. We're entitled to this area variance upon the minimalist demonstration of need. But Delaware River Solar, they don't make the rules. They're not the boss. They are not a public utility and are not entitled to an area variance. And I'm going to start with the first point, that they're not a public utility. There is no binding legal authority that applies to this zoning board that says that this project, this solar project, is a public utility for purposes of zoning. Delaware River Solar has pointed to the Freepoint Solar case in the town of Athens that was recently, this decision was issued just a few months ago from the 3rd Department. But here's the thing about that case. That case did not address at all whether the solar project in that case was satisfied the standard for being a public utility. That was assumed because that issue wasn't on appeal. The other cases that Delaware River Solar has pointed to say we're absolutely a public utility, those are all trial court decisions. They're not binding on anyone, any court, including this board. So then we need to look at what the standard is for a public utility. And here the Court of Appeals in New York has provided a standard. The Court of Appeals has stated, and this is also cited in Delaware River Partners papers, that a public utility is, quote, a private business, often a monopoly, which provides services so essential to the public interest as to enjoy certain privileges, such as eminent domain, and be subject to such governmental regulation as fixing of rates and standards of service. Well, here's the thing. Delaware River Solar is none of those things. It's not a monopoly. It does not have eminent domain power, and it is not subject to the fixing of rates. So Delaware River Solar tells us, don't worry about that first part of the definition. Let's look at the second part, the Rosenberg factors they rely on. And there, Delaware River Solar points to these three factors: the essential nature of the services offered, the operation under a franchise, and logistic problems. Looking at each of these factors in context with the overall standard of what constitutes public utility, Delaware River Solar is not a public utility. Delaware River Solar does not supply an essential service to the district that's actually being supplied with energy here, the town of Boston, this agricultural residential district. There is already an electric utility, NYSEG, here, who supplies electric power to the end user in this area. There is no evidence of brownouts. There's no evidence of gaps in coverage. There's no evidence that this 3.5, 3.6 megawatt project is somehow going to alleviate any risk of that at all. Next, Delaware River Solar is not subject to the intense regulation of a public utility. And here, in the submission I provided to the board earlier, I cited the Court of Appeals matter of Astoria case. And that related to a natural gas plant. And there that natural gas plant said, we're also a public utility. And the Court of Appeals said, no, you're not. Because you're not subject to the PSC's rate-making authority. There's an intense amount of regulation, highly regulated rules by the PSC that govern public utilities. And Delaware River Solar, for the most part, is exempt from those requirements. And then finally, Delaware River Solar does not have the logistic problems associated with a traditional public utility. There's nothing that compels Delaware Solar to go in this particular location apart from its commercial business interest. Its siting challenges are not really that materially different from other types of businesses that have to be careful and specific about infrastructure needs and where certain things are located and where they can attract business. Ultimately, Delaware River Solar is asking this board to make law for it. But that's not Delaware River Solar's job. It's not this board's job. It's actually the state legislature's job. The Climate Leadership Community Protection Act, CLCPA, which Delaware River Solar relies on extensively to say, these are the goals that the state has set, and we need this to be treated as a public utility to meet those goals. Well, what does CLCPA say? What does CLCPA say about zoning and local land use? It actually says nothing as far as preemption. There's nothing in CLCPA that says that there's authority to preempt local land use. In fact, Section 11 of CLCPA is clear that nothing in this act shall relieve any entity of compliance with other applicable local laws or regulations. That would be local zoning. Next, under Section 142 of Article 8 of the Public Service Law, that was recently amended. And it was incredibly controversial because the state legislature gave the Office of Renewable Energy Siting the authority to override unreasonably burdensome zoning regulations. Very controversial authority, impinges on the prerogatives of boards like this. Well, here's the thing about Boris's authority. It only applies to the largest of solar projects. The legislature decided to strike a balance, that for these really, really large ones, 25 megawatts, this project's nowhere near that, we're going to give this state agency authority to override those regulations. It would have been unnecessary for the state legislature to do that had these solar projects of any size just been able to override local zoning based on a simple demonstration of public necessity. Finally, even if Delaware River Solar is entitled to be treated as a public utility as it claims, it's still not entitled to the area variance. There is a lot of lack of clarity, honestly, as to how this standard would apply to an area variance. There's not a lot of law in it, but the law that there is, which we cite in our papers, shows that the traditional standard balancing test still applies here. And that's from the Shefflin case we had cited from the Second Department. And I won't go through each of those criteria because we do that in the submission we provided, but I want to hit on a couple of things. One is whether one of those criteria is whether the requested variance is substantial. And here there's no question, right? Delaware River Solar is seeking to reduce a 500-foot setback designed to protect residential homeowners to 125 feet. And so when we're looking at the rest of those factors, that dramatic change in the variance needs to be considered as far as what those impacts are in considering those other criteria. And Delaware River Solar has acknowledged when the last public hearing in March that it would be very difficult to effectively screen this project from those homeowners that are most impacted by this project. The ones who are actually entitled to that 500 setback, who will not have that benefit as a result of the variance. Delaware River Solar has ultimately not even tried to demonstrate that it can satisfy any of these 5 criteria that this board is used to. So I want to return to this idea of precedent that I mentioned at the start.
Thanks, Joe.
Precedent is absolutely important to this case, but not for the reason that Delaware River Solar says. What happens when you give a bully your lunch money when they ask for it? That bully comes back. Here, if the board agrees with Delaware River Solar that this is a public utility and grants this area variance on that basis, Delaware River Solar will be back, perhaps with a larger project next time. Other solar developers will be back, perhaps with a larger project next time. The board should not make law for Delaware River Solar. Ultimately, the area variances should be denied for the reasons we provide in our submission, as well as for all the other reasons that we'll hear tonight and we heard last time at the public hearing. Thank you.
Okay, anyone else? We are going to have Delaware River Solar respond to a few questions.
No, they're going to.
No, we'll listen to you first.
I'm Bob Penders, 6009 Herman Hill Road. I'm 3 miles away from this project, and this is too close to my home. When I came out from South Buffalo after living 65 years and looking for a new place to live, I took my ride out here to Boston. And I made my decision to move here based on Boston being a rural, warming, residential community. When I was in South Buffalo, and I was 20 years old, we had a family with 9 children. And they approached the zoning board in Buffalo to ask that their home be approved for 6 bedrooms and 3 bathrooms for all these 9 kids. Perfect. It was granted. Keep the family together, remodel your home, bring in your 9 kids. 20 years later, the kids are grown and the kids are gone. The people have this big home in South Buffalo with all these bedrooms and all these bathrooms, and they call in because they want to change the zoning because Catholic Charities wanted to move unwed mothers into the residential neighborhood. And I got up and I objected to that, and I said, when I bought my home, I bought it in a residential neighborhood. Now you want to change it. Now you can expose my 8 and 10-year-old daughter to these girls pushing a stroller with a baby. Where did you get that? Oh, it was easy. You can get one too. So I fought against it, and it was put to the side. They weren't granted that. So one of the things that I think to myself is I wonder how many people are here tonight. I wonder how many solar fields they passed on their way here. I wonder how many people currently in your residence have a solar field in your residential neighborhood. I ask people, thinking where you're sitting, where you've been, tell me where the nearest solar field is to your home. They're very rare and are usually exclusively in industrial locations. When buying your residence, as I did, I can't imagine someone saying, put the kids in the car, we're going to go look at the solar fields out in the country. What I can imagine, put the kids in the car, we're going to Charlie's. All right, put the kids in the car. So we're in a situation very similar to the offshore wind farms out in New England, the Bushes and the Kennedys agreed to having the wind farms put out there with the caveat, not in my backyard, not if I can see it, I don't want it. Okay, not as long as I can't see it, not in my backyard, if I'm buying my house, we already said that. Okay, move on. I'm sorry? I heard something. So, you're representing the town of Boston, you're not representing.
Please
Powell.
speak into the microphone for our record. Thank you.
All right. I just keep getting standing, so I was moving with that. So, you're representing the town here, not anyone particularly representing the town. So, when you go out there, my suggestion, put a plus column and a minus column. Go through what you see as a plus for the town of Boston. What you see as a negative for the town of Boston. When you get done with your list, see which one outweighs. I'm not a gambler, but I'm betting you're going to say that the negatives outweigh the positives. Lastly, I'm a licensed master electrician in Western New York. The installation of the solar fields is guided by Article 690 of the National Electric Code. You can't call just any licensed master electrician to respond to a failure or a fault at a photovoltaic solar field. It's a specialized installation. Many people don't know. Your residential electric is 120, 240 volts. The photovoltaic voltage minimum on DC current is 1,000 volts. They all require a rapid shutdown system, and the reason that standard electricians don't like to deal with photovoltaic systems, while that photovoltaic system is operating, both sides of the switch can be hot. So you have to be very, very experienced, and you have to be specialized in photovoltaic electricity to know how to respond to these sides. The other thing is, I don't know what their idea is for this, but the newest thing with photovoltaic fields is they have what they call, I don't know what the proper term is, the way it's been discussed, they have what they call an orienting field, where all of the solar voltaic fields are motorized. And they're set up this way to follow the sun.
That's what these will do.
I'm sorry?
That's the type that they're talking about.
Okay.
Yes, they follow the sun.
So you're gonna have this thing out there moving and reflecting the sunlight in a residential neighborhood. Thank you very much.
Thank you. Okay, next.
Good evening. My name is Jason Keller, live at 7880 Fedek Road. My property is directly in contact with the property that's being developed. I know we don't want to be repetitive here, so I'll get right to the point. Something I've overlooked last time when I talked to you guys about this is the noise that they're going to make when they put these in. It's going to be an extensive field, so they're going to have to be working on it for quite some time. During the winter, the snowmobiles go back through the gas line. With the snow being a sound killer, I can still hear snowmobiles going in the back. That's with all my windows shut. And I just got thinking about the noise factor that this construction is going to have upon my house, being it's right in my backyard. So I just want to make that point. I know if it's repetitive, I apologize. Thank you.
Thank you.
Jeff Bersanti, 7806 Fedek Road. First, I'd like to continue on with what Mr. Daly mentioned regarding the schoolyard bully. I'm going to give Delaware River Solar a crash course in Public Relations 101. You don't come into a town and say, we're going to do whatever we want, we don't care what you think. You could at least had some kind of meeting, like some of these other solar companies have in other towns, where you get to know the residents, explain some of the frequently asked questions, not come in here with a smug attitude. Oh, well, we're this, we're that. We don't care what you guys say. It doesn't work that way. Public Relations 101, you guys know that. So the next time you guys try to put your little press release or something out there, do something like that. Try to appear a little bit more pleasant and positive to the residents and the board members who are taking your time to listen to your spiel. Anyway, just had to get that out there. Useful tip, I thought. But these images, as you guys can see, are of large poles that are going to be very, very close to my lot line. Now, with these poles being so close, there's no long-term studies that have been proving that there's nothing hazardous to my health. What about the noise, the visual stuff? This is part of the project. This should be subject to the setback. Not 10 feet, 30 feet, whatever, from my house. If something ever were to fall, these three-phase lines this close to my place, I mean, that raises some serious questions. Now, when things like this aren't addressed, or facts are misrepresented, which we highlighted many, not only in the past meeting back in March when they were here, but in also letters from the attorneys representing them, from their project manager and other people, it raises some serious questions on what their intent and what kind of integrity somebody like this has. Coming in here and saying that we're going to do whatever we want, the schoolyard bully analogy, like Mr. Daly said, is not how you gain respect, you gain friends, you gain empathy towards your cause. That's not how it's done. The correct way to do it is to abide by all of the rules and regulations that are put in place there for a reason. Are they here for us, the residents, or are they here for themselves? And I think we all know the answer to that. That one shouldn't be difficult to answer. Now, with that being said, I think we know how everybody feels here. And we've done our research, we've foiled countless documents, we've looked at the cases of many other town members, town boards, and we've seen how things were carried out. For example, the town of Attica, board members there decided to send out a survey regarding these green energy projects. Do you want them or do you not? To the residents of their community. And nearly every time, an overwhelming number of residents said, no, we don't want them. There's instance after instance after instance of misrepresented facts, negative impacts on all of the residents, and also a really great comment that I may have brought up during the last board meeting. I'm sorry if I represented or repeated myself, but Dr. Paul Zarnowski said that it seems like you guys are going after low-hanging fruit to Delaware River Solar. You have some landowner that has his hand out that just wants some money at the expense of the entire neighborhood. They saw an opportunity, they jumped at it. Going after this low-hanging fruit sets a scary precedent to this board, to this community, and to every resident here. And I hope that you take that into consideration. I appreciate your time. Thank you.
Anyone else before I call Delaware River up?
I caught up with him so quick.
Thanks, June.
I just want to hear something.
Wait. Bob Kelak, 7900 Fedek Road.
June Selak, same address.
Okay. First, as we all know, is our issue. We're right next to this property. Our house is up on the hill, the fields are low in the back, we look over top of them fields. There's no way they're gonna build a berm and plant a couple little pine trees and think we're not gonna see them 17 acres of glowing panels in our backyard. We've had a $1 million view vista for the last 30 years, and now for the next 30 years, we gotta look at this glowing trash in our backyard. That's one thing. And then the next thing is the noise issue. The noise issue from hearing that pile driving going on for weeks and weeks, months and months, and probably the rest of the year. And you wanna hear what it sounds like? I'll have a little example here. What's this gonna sound like in our backyard?
We're in here, 7 in the morning till 7 at night,
Day after day after day.
5 days a week.
It isn't like somebody
And on
building a
weekends.
house. It isn't like somebody building a house in our backyard. This is gonna be the most annoying noise for months and months. And there's no way they can put their sound dampers or whatever they wanna call it around it. And the third thing is, I don't care what they offer me, I'm not taking any compensation to try to buy me off on this deal, because I do not wanna have to look at this for the next 30 years. And I think that's all.
I just want to mention something quickly. That blackout in Europe is from renewable energy that was unreliable. That blackout occurred because of solar and wind. Thank you very much.
Shirley, for being here and doing what they're doing.
We didn't get as much applause, really? We're volunteers. We
And you
Throw
guys were
money.
here till almost 11 p.m. last week. Don't forget.
Yeah. It's fresh in my mind.
Hi, Jessica Blasey. I'm here for my Uncle James Gerke Sr. at 7870 Fenwick Road. I just want to ask a question. I've been in contact with New York State Fish and Wildlife. They've contacted the board several times, no callbacks. They've emailed the board, no contact.
What board?
The zoning board and the town in regards to long-eared bats. So I just wanted to read.
Okay, I want to set that straight. I've never received an email from them.
Okay,
I'm
then
the
we'll foil it.
chairperson.
We'll foil everything
Okay.
because they sent one to the.
Because I reply to everything.
They sent it to the solar panel, and they sent it to the resident as well. They gave us interesting things. Cutting down trees aren't hazardous, and with the northern long-eared bats is restricted. This could go on and on and on. Let me get to the one part here about the solar panels, because solar energy related mortality. Solar panels can negatively impact long-eared bat populations through reduced activity and potential habitat loss. Research suggests that solar farms can lead to decreased bat activity, potentially due to factors like altered habitat, changes in prey activity, or even collisions with the panels. Bats of all kinds are attracted to the reflection surfaces of the solar panels. They have also mistaken solar panels for prey, leading to collision. The decimals that are put out by the solar panels disturb the habitat of the bats. The decibels are so loud that the bats get disoriented. And when I was speaking to them several different times, they had stated that you can't do anything. Like you have to have New York State Fish and Wildlife go out there because they're an endangered species. So we will do
Okay,
foil.
it is in these reams of materials.
Right, but no one has reached out back out to them. Sent it to Mr. Nowak in a letter, sent it to the solar company. Nobody has reached back to him, so we will foil that.
That was, I would say that that has to do with the seeker, and the town board gave it a negative declaration. So you might want to follow that up with the town board, because that is out of our hands.
I did.
I just want to be clear on who's what here.
Okay.
Yeah.
We have no ruling whatsoever because the town board gave it a negative declaration on the seeker. it means that there's no environmental impacts. The planning board had given a positive declaration, and then the town board overturned that. So I want to be clear on that. We have no power whatsoever with the seeker.
They emailed
Okay.
everybody.
I just want blame to go where blame is,
Yeah.
okay?
They emailed the planning board as well as Keating, his office. So I would ask him. It is the problem, Keating.
All right, anyone else? All right, then I'm going to bring up Delaware River Solar representatives. If you'd like to introduce yourselves quick, that'd be great.
I'm Molly Messenger from Delaware Solar.
Henry Sommerfeld from Hodgson Russ on behalf of Delaware River Solar.
Okay. Could I just ask these 4 questions that have been brought up tonight? And then you can continue on while it's fresh in everyone's mind and we're addressing them as they came in. Is there anything about the fall zone for the poles?
Anything about the fall zone?
Yeah.
As far as.
Is there any regulations as to the fall zone for the poles because they're as tall as a telephone pole
It would
and
be
they're
the
so
same
close to his
as-
house?
It would be the same as a NICEAG pole in the road. They're the same poles, the same standard. NICEAG poles are everywhere, all over the place. They don't, in general, just fall over. It would be an act of nature if it did, but it's the same installation as in a NICEAG pole that's on everywhere.
But are you guys using the same poles as NICEAG, or are you gonna put more poles?
They're the same type of NICEAG pole, yes.
So it's gonna be an addition with NICEAG.
They're the same poles as NICEAG would use, same.
He's asking if you're gonna be putting in more poles.
Same type of pole. It's the same type of pole that NICEAG uses.
But it's gonna be an addition with.
Yes, there's going to be 5
There's 5 poles.
poles. 2 would be closer to the road and the other 3 are at the discretion.
They can be separated up to, I think, 150 feet. Separated up to 150 feet apart.
Okay. How long is the construction time?
Usually between 6 to 8 months. It really depends on the time of year. So it depends on in the summer if they can have all the materials there and really move forward, or if it's in the winter time. Like was just brought up, there are restrictions on the time of year for construction because of the northern long-eared bat, which we're aware of. The town got the IPAC letter, we have the IPAC letter that makes us have restrictions on the time of year that we can cut down trees.
Okay, do you want to say anything else about that?
We have to follow the laws for IPAC, that's what happens. So you get a letter back from IPAC, IPAC letter states that you do have northern long-eared bat in the area, and then you can't cut the trees between March and October. So you have a very short window. This project has very few trees to cut down, it's only in the back corner of the property. It's not a lot of trees, but they can't be cut down in that window.
Thank you. And I also would like you to address the status of not being a public utility, as Mr. Daly brought up.
I'll let Henry speak to that.
Okay.
Yeah, I thank you, Madam Chair. So, Mr. Daly spoke about not being a public utility, and I want to address that, but I first want to address the point he raised and was repeated, that we're bullies. I want to be clear. Bullies get something that they're not allowed to have, that they don't have the right to have. That's not what we're doing here. We're asking before the board with the legal requirements for permission. I understand some people feel that we're coming in and, you know, that they're not happy with the way things have been presented, but we've presented only what the law says. And this goes to Mr. Daly's point. We're not a public utility. I disagree 100% because that's not what the law says. When we were here last time, Mr. Kenyuk and I spoke about the third department ruling that Mr. Daly also brought up. That ruling holds from an appellate court that is binding that these projects are public utilities. Now, if we wanted to legally squabble over that decision, I would direct the board to our letter. We've cited to 3 trial court decisions, one of those decisions here in Erie County, one of those involving Delaware River Solar, one of those involving an area variance. Those are binding. They are court decisions that are binding on this board. So I disagree. Mr. Kenyuk and I went through all of the criteria last time. The Court of Appeals holdings in Hoffman and in Rothenberg were cited by those courts in holding that these projects are public utilities. If the board is inclined, I'll go through and explain everything we covered last time, but between our letter, our subsequent follow-up, and the discussion I had with both council and the board, it is right in the decisions that we've provided you. So on the law, I disagree wholeheartedly with council. That is not what the courts have held. And that's why the public utility variance standard is what is to be applied here.
Okay, those are all my questions. Thank you.
We had a nice site visit with some folks today from the board, and we appreciate you guys coming out because it's important to see the site and what we're actually looking at and what we're talking about. There were a couple of questions that I looked up, the board had asked me to. The NICEAG costs for upgrades are somewhere right around $560,000. That's what we have to pay in order to upgrade the three-phase lines. That's a conceptual cost, so that's something they give us, and that's a roundabout in case. So that's what we have to work with. We have to pay that money to NICEAG to do all the upgrades back to the substation.
So that's the tap-in?
Yes. The substation is the South Park substation. It's in the Lancaster group. It's quite a bit of ways from here. I was not able to find the actual address. I followed the line for quite a long time and wasn't able to find it on the map, so I'll have to get you the address of where the substation is.
So it's near Lancaster, is that what you said?
It's the Lancaster division, and it's the South Park substation. Another question that was asked was how many panels were in that first section. It's right around 850 panels in the first section. Around about, just a crude way of trying to put that into megawatts without being able to speak to my electrical engineer, is probably somewhere in the realm of half a megawatt to 3/4 of a megawatt would be removed from the project without that 800 panels.
So right now your project is at 3.4?
3.4.
So you could potentially be looking at
2.93,
Okay.
somewhere in there is where that would land. Just a real quick comment, we don't have any approvals from the boards. I'm not sure that one letter was a little bit misleading, and maybe that's why there was a second letter. We don't have any approvals. I think we're all clear on that. And we are asking for the variance from the 50 acres to go from 73 to 50. So I just want to be clear that, you know, we've had that in the record for quite some time.
That's just an opinion.
Yeah, I just wanted to clear things. We are aware we don't have any approvals. There are.
Right.
We have suggested a couple of different times about some landscaping. We know that it's difficult. We've brought that in front of the board. We're aware of that. I have given my card to a couple of the residences, and we did send out a mailer to the residences, so we have tried to communicate, but we have not gotten any communication back. In our letter for public hearing, we did talk about talking to the adjacent neighbors and seeing if we could even plant trees on their property to try and do some more screening that may be more adequate, because screening on our property that we're leasing will not solve the problem. We're aware of that. We've talked about it. We talked about it in the last meeting. If there is landscaping on our property that we can put in, we definitely will. That's something that we want to do. We want to work with the neighbors. If there's landscaping to put on other properties, I think I said this last time, we would also be willing to do that too. We've done that in other areas of the town, or not this town, other. We covered a lot at the last meeting. We covered a lot in our response. I don't know if the board has other questions. I don't want to waste anybody's time on further discussion.
I had a follow-up question. There's been many concerns brought about screening and the noise, and you're going to attempt to address those things. Thank you for that. But there also has been a concern of property value and how this solar farm will negatively impact future property values. I wouldn't be able to sell my house because people don't want to look at that type of thing, that type of underthing. Would you be open to some type of property value protection plan for the current residents, homeowners that would be affected negatively, their property values would be affected negatively by this solar farm going in.
I have not heard of such a plan. There have been sales in and around this solar field, knowing that solar field was going in, that are above the value that they were originally sold for the last time that we looked. But, Henry, do you want to discuss any of that?
Certainly, and we addressed this, it's number 18 in the letter, just for the record about property values. There is no confirmatory study that shows that being near a solar project is going to reduce your value. Value of properties contains a lot of different things that go into value. And I think part of the issue is, how do you say, well, my property value went down and it's attributable to the solar project? I mean, how do you prove that? You know, remember, and I articulated this to the board last month, this is an allowable use. It's an allowable use. All we're talking about is size of the project.
Right, yeah, I get it.
So I think it would be very difficult and speculative to say, my property value went down, and therefore you're responsible to pay that.
Fair enough, but it could go a long way with the neighbors,
But what,
the community. That's all I'm saying.
this
You've
is.
got to live there, but the gentleman has to live there.
I
so-
totally understand, and this has come up, and I will say every time it comes up and we kind of pose the question back, of what does that look like? There's never been a proposal that I can actually digest of, what is the trigger? What is the trigger? Is there an amount? How do we qualify that because of the solar project, the property value is affected? Because this is adding to the tax base, so.
What did you call that?
I called it a property value protection plan.
Yeah, and if I might just note, I'm just reading the letter as you posed the question. The response in relevant part was, in an investigation of the adjacent properties, this was for a solar project in New York and Cattaraugus County, there were 2 sales within the time frame of the approval of the solar field that were above the assessed value, and there were also Zillow estimates with increased value above the original sale price. So I think there are a lot of
Were
things.
they the true assessed values, or
According to this letter, they were.
had there been a reval done, or was it?
Well, to use your same
No,
argument
I mean,
against
there's a
you,
lot of factors.
you can't necessarily attribute that to the solar farm.
But Madam Chair,
After it was already finished.
I think we need a bigger sample than 2, anyways.
But point being, I think, Madam Chair, you hit it on the head, there are a lot of variables, and that's quintessentially the problem with how do you say, because of this, then that?
Fair.
But
I think common sense, maybe. Yeah. I don't know.
I think there are too
Moved to
many
the country for a
variables.
reason.
Right.
I
An
think,
allowable
I'm just
use.
saying, it could also go along with the neighbors, you know? Might go along with the board.
If I may,
Yeah, please.
I mean, the property value, so the property value protection plans, which I am familiar, which aren't for solar, I haven't seen solar, but
Are you with the microphone, Dwight?
oh, I'm sorry, there we go. I've seen them for other types of developments. Usually there is perhaps a percent trigger, but the determination of whether there's an impact from solar is usually a comparison of certified appraisals. Usually, I think if there's not a risk of a property value loss, then actually the developer would have low risk of paying, because if there wasn't going to be a property value, the cost of the plan is zero. Right? So that's of the ones again, I'm not familiar one for solar, but I've seen several for other types of.
Anything else, Stephanie?
So I have a question regarding the photovoltaic electricians. Would you be working with someone local, or in case of an emergency, would they have to wait for someone to come in from a different town, a different company?
There's an emergency contact that's local that will have all of the other contacts within our operation and maintenance plan. And then we also show the fire department everything that needs to be done. There's a whole class that'll go on to show them how to disconnect the solar field, what needs to happen. As far as the local agent or the electrician, the actual electrical contractor, we try and use local contractors if they're certified to be able to do that, otherwise it will be somebody brought in.
Would Delaware, I want to call you guys Delaware North, because that's just the
I
name.
know, I
But
always
it's not.
do too.
With the Delaware company, would you all, would you be willing, open to that section that we talked about, the first section? Would you be willing to scrap that section and drop your project down to a 2.9/3 project? Is that something that is open for negotiation?
We can definitely talk to the owners, I can't speak on that, at this meeting. However, I will say that just dropping that one section solves one homeowner's view, but not another homeowner's view. So I don't know how we drop one area and solve one location. I just in talking. We can certainly go back, we can certainly ask the owners if that's something they'd be willing to do, for sure. But I don't know that it solves the entirety of the issue.
When we were there today, we talked about the visual aspects of it. And I had inquired as to whether or not we could do a visual simulation from each of the homeowners that would be affected as far as their view. Is that something that you could do between now and our next meeting?
If we were able to get the pictures sooner than later, we'd have to get the pictures. It's about a 2-week turnaround for us to send the pictures to get that actual visual. So we'd actually need access, and or if we can't get access, we would need legitimate good pictures from the homeowners.
And I think because those poles are so close to the neighbor, we had talked about options for relocation of some of them over towards Nowak's property. I guess I would like to hear something more definitive along those lines, as, distances.
Yeah, the entrance of the driveway can move down further towards Mr. Nowak's house. That can definitely happen. The first 2 poles we discussed in the field, we don't really have control over because those are 9/6 poles. So those poles, have to be 50 feet apart, and they're off of the easement of the road. So within 100 feet, there's going to be 2 poles there. We have no control over that. After that, the remaining 3 poles can be spaced out quite a bit. So you the way to the back by the time you get to the 5th pole. But the driveway location can be moved. There is site distance. So if we need to move that closer to the Nowak property, closer to the house on the other side of that area, that's something that would not be a big lift to move the driveway.
And the driveway that we went down today is the driveway that is going to be the driveway that's used for construction and the solar fields.
It'll be built out to a 20-foot road.
Okay, so are they gonna put stone down, or what are they gonna do?
Correct, it's a gravel road.
Okay. 20-foot wide,
Question with the setbacks that you're going for, to be that close, is that the fence, or the array is inside of there, or the fence itself's gonna be closer to the property line after that?
The setback location is to the fence line.
And that's a what, 6-foot fence, 8-foot fence? 8-foot fence. So you're gonna take that view and everything and block it all off. You're talking about screening and everything else. So you take everything and just encapsulate it.
It's a deer fence. It's not a solid fence. That's, if I'm answering the question correctly.
Well, it's a fence.
It's
out in the
black
middle.
plastic. Deer fence. I know, because I asked it. All right, well, we received a brief from the Citizens of Fedek Road attorney that we have not had an opportunity to look at. It was just in our packets that we got tonight. So we have that homework to do. And you guys have your homework to do.
So I guess 2 follow-up questions. Could we get a copy of that brief tonight so that we could also review it, or maybe email tomorrow?
Mr. Daly
I have a paper copy.
Okay, perfect, good, thank you. And then the visual study is still kind of in limbo, so should I call tomorrow or early next week to find out how to mitigate that?
Well, I think most of the residents are here tonight, that it would affect. If they would like to stay after and speak to Molly, if you would like that done. I would recommend it, because nobody knows what's gonna happen here, so I would wanna know what I'd be looking at and what mitigation could be done. If it was me, just to be on the safe side.
May I
Yes.
approach?
You may.
I don't know how familiar Ms. Delaware is with the National Electric Code.
Can you say your name again, please?
Bob Henders, 6009 Hermanville Road.
Thank you.
But when you have overhead aerial wires, the minimum requirement clearance to the ground, to the bottom of that wire is 10 feet for pedestrian traffic. The minimum required going over a driveway is 15 feet. And any access for a large vehicle would be 18 feet. So to maintain those heights, if she's saying they're going to only have a pole 150 feet apart, they probably have to be 110 feet in the air to keep this, the dip from that to maintain that 18 feet clearance. That's why in those photographs that were presented, that's why the poles are so close, to maintain that clearance from the ground. The second point I wanted to bring up was the counselor was saying they're a public utility. My understanding from the Public Service Commission is a public utility is one that provides a service and meters that service for the provision. I don't believe that Delaware is metering anything other than the supply they were giving to NYSEG.
Very good, correct.
I'll just say we can continue to go on the carousel ride. The courts have already held that solar companies, including DRS, are subject to PUE standards. They have a solar project, it interconnects with the grid distributes the utility, which is the electricity, for which there is a need under the CLCPA. I mean, it's been held time and time and time again, including with DRS.
And my response to that is, there's 9 Supreme Court justices, and there's usually a finding, and there's a 5-4 split. So this lawyer can come in with his idea and his intention, but we'll find another lawyer that will counteract his until we get a response that comes down to the finding.
It's not a battle of opinion. It's settled by the courts, by the state courts.
In this instance,
I've already covered this, I'm not going to.
So I'm going to stand in the lobby. If any of the neighbors would like to come talk to me about trying to do a visual or giving me pictures, I'd be more than happy to do that, which is fine. The only thing I would ask for tonight's meeting is perhaps we could close the public hearing at this point. I think we've exhausted a lot of different good issues that we're working through.
Yeah, definitely. All right, is that it? Make a motion to close public hearing.
I will second that.
Ms. Fryer?
Yes.
Mr. May?
yes.
Mr. Baylor?
Yes.
Ms. Zielinski? Yes. Ms. Ruth?
Yes. All right.
Before you go.
Thank you for coming. Thank you. Thank you for coming. It was interesting, thank you. I can't believe they think everybody's so stupid.
All right, we're gonna be switching gears now. We're
Property
going
values
to
go up.
listen to petition number 635 Horseshoe Hill LLC, 7588 Lower East Hill Road, seeking several area variances for setbacks, area variance of 17.14 feet for side yard setback of the existing metal building, area variances of 88 feet and 2 feet. Hey, you guys. Would you discuss out in the hallway, please? Thank you. Give them the courtesy that they gave you. Thank you. Oh, hi, Patty. An area variance of 88 feet, 2 feet for side yard setback of the manure building, area variances of 30.6 feet, 72.21 feet for side yard setback of the stable building. We've already held a public hearing on other details for Horseshoe Hill, but this will be another public hearing for just these variances that we're setting up. So I would make a motion to open the public hearing.
Second it.
Ms. Fryer?
Yes.
Mr. May?
Yes.
Mr. Ballard?
Yes.
Ms. Alinsky?
Yes.
Ms. Ruth?
Yes. From Sarah Desjardins, our planning consultant, regarding petition number 635 Horseshoe Hill, seeking several area variances. These proposed actions are classified as unlisted actions and therefore not subject to review under seeker. From our assistant code enforcement officer, respectable chairperson, rude and conscientious board members, petitioner wishes to obtain 2 variances for his property at the above address. The variances required are as followed. Pursuant to Article 11 RA Residential Agricultural District, Section 123-51B2, which states other principal buildings, accessory buildings, and farm buildings, except as otherwise provided, each side yard shall equal 30 feet or a distance equal to the height of the principal building. The metal building which was placed on the property is one corner at 12.86 feet and another at 13.13 feet from the property line. Variance is necessary for the decreased distance to the side lot line. Required 30 feet, actual is 12.86 feet. The variance is 17.14 feet. Next, pursuant to Article 11 RA Residential Agricultural District, Section 12348A3, which could otherwise require a 100-foot setback to our district property lines for manure and livestock confinement areas. To permit reduced setback to the manure bay, which is within 12 feet of the north property line and 98 feet from the south property line, the stable building, which is located under the dwelling and is 27.79 feet from the south property line in an adjoining our district and 69.4 feet to the north adjoining our district property line. The manure bay north side required 100 feet, actual is 12, variance is 88 feet. And then the south side required 100 feet and the actual is 98 feet, variance of 2 feet. The stable building north side required 100 feet, actual 69.4 feet, variance is 30.6 feet. South side required 100 feet, actual is 27.79 feet, variance is 72.21 feet. This variance is necessary to correct an issue not caught when a previous code official issued a building permit for the construction of the structure. We also have some letters to be read. From Joan Woodrow. I have tried for 2 years to get the electric fence at 7588 Lower East Hill Road moved 15 feet away from my property line according to code. Electric fences are highly regulated because they're inherently dangerous. An electric shock cannot just temporarily harm someone, but can cause a person's heart to stop beating. To have an electric fence with who knows how much voltage in such proximity to a children's play area is an accident waiting to happen. The town and owner of the property should be more diligent to the dangers the fence could cause and hereby be civilly liable. I am hereby putting the town of Boston on notice that if anyone lawfully on my property gets hurt by that fence, my husband and I are bringing a notice of claim against Boston for civil damages. Second, we are placing Mr. Jeffrey Fisher on notice as well, as we have consulted with a personal injury attorney, Scott Printup, on this matter, and this is what he has advised us to do. The building inspector has an ethical obligation to my husband and I to act in our best interests, and as such, code violation or not, the danger is there and is an ever-present danger to anyone in our yard. The potential dangers of injury or worse far outweigh the desire to keep horses in their rightful place. And this one is from Karen Cole. Dear Chair Rude, while we are the neighboring residents can respect the position of the Nice Dam and Horseshoe Hill LLC, we are respectfully requesting the Town of Boston decline the land and use variances for the subject property located at 7588 Lower East Hill Road. When looking at the zoning maps for the Town of Boston, the particular area of 7588 Lower East Hill Road is located both in the R2 and RA zoning districts. We agree that it is an undue burden and hardship on the neighboring properties, along with health and safety concerns, not only for the residents and visitors, but also for the horses, for the Town of Boston to approve some 5+ variances for the property. We have some 30+ years of residence on the hill and weigh heavily on health and safety concerns for our entire neighborhood. The residents bought the parcel of land in 2020 with ill intentions, lack of integrity, and made fictitious statements. Basically, the Fisher and Benning household had built a home, a boarding stable, and installed a fence without first seeking the proper permits and variances from the Town of Boston, and have been allowed to leave these in place while violating the Town of Boston zoning codes. The family has created their own hardship. We agree they can build, however, buildings, fencing, and any other buildings or installations should be done within the Town of Boston code and conducive to the size of the property, and not allowed to extend onto the neighboring properties outside of code or outside the footage allowed to the neighboring property. Our bullets are referenced below as to why we believe the subject property should not be granted the land and use variance. Neighborhood concerns: we the neighbors fear the proposed change or addition will alter the essential character of the neighborhood. Allowing a larger building than what is currently allowed in the zone will block sunlight for neighboring properties and disrupt our views. This will lead to hardship for the existing property owners. Another issue is related to public welfare, health, and safety. We believe that the proposed variance will have a negative impact on the well-being of the community, horses, and visitors. Property value considerations. A significant concern is the impact on property values. No one will want to live where the views and sunlight are obstructed. This is why we live in the country. Traffic-related issues. The proposed change will lead to increased traffic congestion, safety concerns, and difficulties in access for first responders, school buses, snowplow drivers, county lawn mowers, etc. Please see the attached picture of stuck truck in the Fisher's driveway. We are avid animal lovers, but are respectfully requesting the support of our Town of Boston to adopt our position and say no to the requested variances. Attached are pictures evidencing the subject property reflecting the high snow levels, ponding water, and stuck prime truck in the Fisher's residence driveway. Please remember we live in the Colden Hills and folks tend to forget about us, but we want to be heard now. Sincerely disappointed Boston resident. And there's some pictures of ponding water, snowbanks that are taller than the vehicles, and the truck that was stuck in the property. And this one is from Rick and Elaine Kaminsky, 7626 Lower East Hill Road. I purchased property at 7626 Lower East Hill Road in 2021 to have some peace and quiet as I retired. We, like others, follow proper codes, rules, and regulations. We applied for proper permits, and only then, after permission was granted, started construction. I then needed a shelter on the property for tractor and equipment. Again, I researched what was allowed, applied for a building permit for storage shed. Once received, the shed was built. I did not build and then asked for forgiveness. I did it the proper way. Once we moved in, I learned that the neighbors, the Bennings, at 7588 Lower East Hill Road owned the property. However, for reasons unknown, it was put under the name of Jeff Fisher. Jeff is the boyfriend of the Bennings' daughter. Already things seemed sketchy to a veteran police detective, LOL. They had built a horse barn on this property and then, after time passed, added on living quarters on top of this structure that was built for horses. This is illegal and goes against Town of Boston building code. These living quarters were constructed for their daughter and her boyfriend, Jeff Fisher. I then learned that the Bennings Fishers constructed an electric fence. This was also against code since it was put up too close to the neighbor's property line on the south. Bennings Fishers stated that a contractor was hired to construct the fence and did not know it was against town building code. As months went on, I observed various equipment was brought onto the Fishers Bennings property. A lot of construction was underway in the rear of their property, which you can't see from the roadway. I then observed that this area was being prepared to have some sort of large building erected. Some short time later, I observed several large roof trusses being delivered. I seen that in 2023, Fishers Bennings secured a business LLC license, refer to the last page, and a web page which promoted their business. As this was all happening, I learned that this was all done without any authorization or permits from the building inspector of the town of Boston. I then learned that a neighbor notified Boston building enforcement officer of the construction. After town building inspector was advised, only then was construction halted, otherwise it would have been constructed without the permits and authorization from the town of Boston. I can only assume if this large structure had been illegally erected, there would have been no real consequences based on past practices. The owner's illegal living quarters were stuck in along with illegal electric fence and nothing was done. I believe the owners learned that it was easier and better for them to use the old saying of ask for forgiveness rather than permission. Fast forward now, lawyers, building inspector, and zoning board gets involved. Hopefully no politics, meeting after meeting. All surrounding neighbors voiced their highly negative opinion on the construction of this large building. The zoning board voted against continued construction. Since Fishers Bennings did not get what they wanted, they appealed the decision. More meetings and still all negative feelings from surrounding neighbors. The concerns include, but not limited to, the enormous size of structure, rainwater drainage, flooding, disposal of all the horse manure they've been spreading it in the back field, which will get into the neighbors' well water, noise from horses, dust and noise from horse trailers up and down the stone driveway, extra lighting around the building, the safety of horse trailers exiting properly onto Lower East Hill Road, along with the decrease in surrounding property value. As we now await the outcome of appeal decision, the Fishers Bennings still did not stop. The ground was additionally prepared, drain tile was now constructed on the outer perimeter where the building would be built. Stone was hauled in, additional fencing was installed. The roof trusses that were originally stacked were moved and are now placed in position on the ground. Area neighbors and I talked, and we all feel that the Fishers Bennings are going to build what they want and do what they want regardless of any authority. We respectfully request that you, the town of Boston, step in and do what's right for the neighbors. Please put a stop to this. It is wrong. Any loopholes that are being used are just that, a loophole. The property is way too small for a horse training, riding, boarding arena of that size. My understanding of variance authorization is only as the surrounding neighbors are not affected by the change. Otherwise, variance laws stay in effect and are enforced. The integrity of our community relies on the steadfast enforcement of these regulations, which exist to preserve the peace, safety, and property values for all residents. Allowing such blatant disregard for established procedures sets a dangerous precedent and undermines the trust we place in our local governing bodies. We urge you to uphold these standards, ensure that any construction or alterations on the Fisher Bennings properties are conducted within the bounds of the law. Thank you for your attention in this pressing matter. I'm also concerned about the neighbors being so upset if construction continues that they will call or complain to the building inspector, town supervisor, dog warden, SPCA, ECSD, NISHIP, ECHD, TBHD, and anyone else or any tiny wrongdoing that occurs on the Fisher Benning property. This would be a waste of taxpayers' money and a waste of time for departments that could be involved. Whatever happened to trying to work and live together as neighbors to help each other when needed? As a police officer, I've seen and been involved with neighbors' disputes. They never act good. They never end good. In closing, the Bennings Fishers did not research the property, the above property, which is not suited for what they wanted. They made the mistake, and we, the neighbors, do not want to sacrifice for their ignorance. It's a residential neighborhood, not a place for such a large horse arena business. Please act from your heart and according to how the neighbors elected you feel. We don't want it. Please do what is right for us.
You gotta be on the radio.
It was him!
97 Rock, we're putting you on there.
I was employee today once, just saying.
Did you do that all in one breath? I think so.
Demands.
I think so.
You guys are killing me. I need a beverage.
Jesus.
All right. What is this? That was just handed to me. I didn't even, I'm just looking at this here. All right. Oh. All right. All right, so you got that, right? All right, folks, so I had calls this week about movement, construction, concrete trucks. So as we said at the last meeting concerning this, it went to Ag and Markets. We denied this initial application. They took it to Ag and Markets. They have an agricultural designation, so it takes it out of our hands as far as the riding arena, as well as basically these 3 variances, because they get leniency and they don't have to follow the code to the letter because they now have this new designation through Ag and Markets. So I just want that to be known and understood before we get into any questions and answers, because we only have so much power here, okay?
Can I come up there
You
1 second?
certainly may, and state your name and address and speak into the microphone.
My name is Tom Woodrow. I live at 7600 Lower East Hill. I'm adjacent to Horse Hill.
Your wife wrote this letter,
Yes, there
the
you go.
first one we read.
All right, look. 2 years ago, this thing started, where we actually sat here in the middle of the summer. We hired an attorney, brought the attorney in, and had the attorney do the talking for us. When we got done, you finally said, Lisa, you said, it pains me to do this, but we have decided that we cannot grant the variances that you asked for at the time. And then you said, it's not fair to the horses, and the property just doesn't suit what you're asking to do. All right, has the property gotten larger? Did the horses
I
get
still stand
smaller?
by that.
What
I still
happened
stand
here?
by that.
New York State,
New
New York State Ag and Markets, that's what happened.
You mean, in other words, every town,
We're
as soon as New
overruled.
York State steps in and says, hey, you can't do that, it's fine. So you guys, no one anywhere enforces any codes?
We'd like our attorney to speak for us here on this one.
Sure,
Corey.
go for it, Corey.
Are you kidding me?
Address it for you. It's confusing and it's,
No, it's not confusing, it's bullshit. You people are not enforcing any of the codes, not one of them. And you haven't for 2 years. You know, I don't know what to say. I mean, there's really nothing else I can say. This is wrong. You people all know it's wrong. How does the whole town board live with themselves with this going on? I realize you're people who just volunteer to come up here and you spend your time to do this. And I really shouldn't be going after you, but you know what? Maybe you should go after somebody and find out what's wrong here. You know, they made some sort of a comment about a schoolyard bully. These people are a schoolyard bully. They do what they want to do, and if it doesn't work out, they complain until they finally get an answer from somebody.
Money.
It's not right.
Thank you.
Sir?
Can I come up?
Sir.
Woodrow. Mr. Woodrow.
Mr. Woodrow, can I address something that you said?
Pardon me?
I have a question, Mr. Woodrow. Can I ask you a question?
This is Corey Auerbach. He is the attorney that's been,
Yeah, I know. I know who you are. I really don't. I don't even want to listen. You know, all you do is you tell me why it can't be done.
I'm sorry I tried to have a conversation with you.
Rick Dominski, 7626.
Rick, I don't want to hear a repeat of anything that's in this letter that I just read.
Okay, all I'm saying is, again, talk about bullies, come in, do whatever you want. Just, you know, I had to get permits. Why don't they have to get permits? What? I don't get it. What are you people doing? Now, as far as the state goes, my understanding to that letter from my attorney said that the state strongly suggests that you people give them a little more leeway than you would other people that may want to put in a factory or some weird thing or something like that. The state didn't say you have to do it. They said to give them some room. They didn't say you have to do it. They said give them some room. Give them some room. Give them a little bit, but don't give them carte blanche. And that's what you people are doing from day one. When I found out that they had to put the name in the residence and property in somebody else's name, I mean, come on, what is going on over there? All the stuff they did, all the variances, they should have done that before they built it. And now you're gonna go, oh, it's okay.
We did not.
Well, it's still the town of Boston. So now you people just, oh, we're
It was
gonna
the
okay it,
code-
you
was
have to fix it.
Prior code enforcement officer.
Too bad, it's still the town of Boston. They screwed up, you guys seem to have to make it right now. You can't just say, oh, it was him. It was the old mayor that come up with, no. It was the town of Boston that did it. And somebody needs to be held responsible for making that stupid decision. And all I'm hearing is politics and money. Now, I don't know, but I'm telling you, I can't believe I moved out this way. I'm just
Well,
ashamed
I
of
can
you
tell you,
people.
I'm not
I don't know
making
how you
anything
can
off of
sleep,
this.
how you can continue to go on like this. I was always brought up, help each other, work with each other.
You're out of order, sir. How dare you disparage these people like that? You should be ashamed of yourself. These are volunteers.
Yeah. Do something about it. Just give them whatever they
I
want.
get that you guys are angry, but you don't have
Yeah.
to be uncivil.
Yeah.
You know, we've been
Follow
angry.
the money.
We've been angry for 2 years trying to get this fixed, and it just gets progressively
Do you
worse.
want them to do what the law says or not?
Yeah,
Okay.
move the building, move the don't give them the
We're on the
variance.
same page. What I'm
Don't
hearing
give them
from
the
you guys is
variance.
that you want them to do what the
So
law
all the codes in the town of Boston are no longer good for any, they can do what they want, and the rest of the people in the town have to abide by it.
Can we just, all right, that's enough. Thank you very much. Thank you very much, everybody. I'd like to invite Horseshoe Hill folks up. I think that we have some questions from last time, or we have something to talk about, right? The lights, do we have anything? Great, come on up.
Just the setbacks.
Setbacks.
Is this working? Okay, if I may, just start with one point of
State your
clarification.
name.
I'm Lauren Adornetto. I'm an attorney with Phillips Lytle. I represent Horseshoe Hill LLC, which is the applicant for 3 variances before the board here. So just to clarify the record in response to some of the comments that we heard tonight, and then also going back to the last several meetings that we had in November, and then that we heard again in January. Just as an overarching global correction, when the Fishers acquired the property in 2018 and pulled permits to construct the stable building in 2019, they purchased the property and began the development of a commercial horse boarding operation with the express intention of developing this property for that purpose. And before they purchased the property, they made sure that the property was suited for that use. And certainly the board is aware, throughout the long analysis of the ag and markets components of this application, that the property itself sits within a county certified agricultural district. So agricultural districts were established as a program by the state. And so of course the state...
Laura, they understand that.
Okay.
They're clear about that.
Okay, so the property owners didn't purchase an ill-suited parcel and then try to ram a set of inappropriate buildings onto it. This parcel is designated to be developed in a manner that is consistent with the agricultural district's
Laura,
program.
if I could interrupt you one moment.
Mhm.
I've had horses since I was 9 years old, and
I feel like that.
tonight, yeah. I've had horses since I was 9 years old. I'm gonna be 67 in August. It's a long time. I've had 28 horses over my lifetime. I've lived in all different types of settings with my horses. When I said that it pained me to turn this down, you will not find a bigger advocate for horses in Boston than me. But that property, excuse me, is just not conducive, and that's what I explained when I was up there to Mr. Fisher, and I showed him why it wasn't. I have a riding arena. I know what it's like. I know, and I don't allow people to come and use my riding arena. They're bringing rigs in with horses to rent space. There isn't even a place to turn around a rig up there, especially if there's somebody driving it like me that isn't the greatest driver with a truck and trailer. The drainage, the slope of the property, even just the slope in the pastures, that's not even good for horses' legs. I mean, I looked at all those things, I brought them all to his attention, and they didn't care. I mean, the proof is gonna be in the pudding when they get this thing put up. I gave them calculations as to how much water was gonna be shed off those buildings. I should show them the video that I had today from the rain burst at my house over just a small portion of the roof that attaches my barn to my riding arena, and the water that was shed off of that in just that short amount of time. That's my concern. It's beyond what the zoning is. I was looking after them, but they don't want to hear about it. I was trying to give them my life's lessons and say, maybe you should think about a different piece of property to do what you want to do, to build your dream. I have nothing bad to say about what their dream is. I just don't think this is the right piece of property, and that's why I voted against it. And I think that now they're putting a round peg into a square hole. But time is going to show them. I mean, they've gone around and found the loopholes and the ways to get around things. I mean, what can I say?
With all due respect, seeking protections that a farm operation is entitled to under the state's agriculture and markets law is not seeking a loophole. It's furthering the policy of the town's residential agricultural district. It's furthering the policy of the town's comprehensive plan. And additionally, its draft comprehensive plan, which calls out time and again the importance of protecting farmlands.
Can I shortcut this, please?
Please.
Okay. Lauren, they were not eligible for the protections of the ag and markets law. They became eligible for the protection of the ag and markets law. When you made your decision, they were not eligible for those protections. Now they are eligible for protections. So I don't think we need to go back in history. I don't mean to interject myself where it's not appropriate, but we have an application before us, the past is the past. Why don't you present your variances, they can take an action, we can move on.
Right, so just to put a fine point on it, the variances that we're here for tonight are not in connection with the riding arena. There are 3 variances for
I know,
existing.
I made it clear, I believe, that it's already done.
It's the manure bay and the buildings.
Yes.
Equipment building, the
Correct.
beds.
So, a question that I do have though. With these variances, would there be any consideration? Because to me, there is a health and safety concern with that electric fence in the front of the building that's 2.2 feet away from the property line, where children do play. Would they consider moving that fence or removing that area now that they have everything in the back that they're gonna want?
I addressed the fence concerns fully in the written materials that I submitted in January because I did hear the Woodrows' concerns with respect to the proximity to their lot. So we've heard that, we've responded to that, and I'll just reiterate what I've said. So the fence is itself on the Horseshoe Hill property. So anyone who's standing on the Woodrows' lot is not facing any risk of electric shock. Additionally, the fence is labeled so that anyone who is approaching the fence knows that they're approaching an electric fence.
Is a kiddo gonna know? Like, is a
And my
4-year-old
arm
gonna
is
know?
longer than 2.2 feet if I was standing on the other property.
Additionally, the variances that are before the board tonight don't go to the location.
Understood, understood. We're just asking.
And the ag and markets guidelines have been exceedingly clear that.
So there's no leniency to that.
It's important to the farm operation to be able to use the limits of its property for its
No
farm
wiggle.
operation.
What
The fences are in a
if we,
different location.
what if we changed it not from, like, that section was not an electric fence? What if we just did?
In the written materials, I point out that the fence is not
No
on
wiggle is what you're
100% of
saying.
the time. It's
He's
off
saying no
most
wiggle.
of the time.
On that.
Right,
Okay.
right, so the concessions we can make on the fence are things like the labeling, keeping it off when the horses aren't out. Those are the ways that we can respond
That's
to
not
the
good.
neighbors.
as well at that meeting?
There is heavy screening on the Woodrow property, so that there's just a limited portion of this fence that isn't fully buffered, and particularly the portion of the fence that the chair is most concerned about, that front corner where it's right up next to the property, heavy vegetated screening. It's not an area where a youngster is gonna tumble off of a playset and get shocked. The area where there's a lack of screening is where the fence is 14, 15, 16 feet off the line, and
Is that
it's
right
not
by the
up to
playground?
this.
Right by the place hut? Is that, how far away is that?
15, 16 feet off the line at that point. And where it's closest to the property line, there's plenty of vegetated screening. And it's also closest to the road, so I can't imagine an environment where a kiddo is in that front corner of the property and approaching the fence.
If I could, to the property owner, this is your community. You have to live with these people.
Yes.
It might go
They
a
don't
little
care.
ways if you were
They don't care.
to wiggle a little bit on that fence. We can't make you, it's an ask, we understand that.
I've tried being neighborly, it doesn't go both
Well-
ways.
If you're gonna address your board, just come up and state your name and speak into the mic.
I mean, someone's gotta make the first move, and I don't know, like, you guys live in a neighborhood.
Jeff Fisher, 7588 Lower East Hill Road, owner of Horseshoe Hill LLC. I've tried numerous times to be neighborly, be friendly with these people since day one. Rick has come to my property prior to constructing his house, asking for survey information, knowing exactly how far back his property goes. I've had the Woodrows over when the building was being constructed, took them through the house, and nothing but neighborly. It has been only recently that these have been issues. The fence has been there for years, established for years. Why is it only in the past 2 years that this is now becoming an issue? Nobody has addressed the board in 2018, 2019, 2020. It's only the last 2 years since we tried to do this. So what's changed? We have been as neighborly as possible with these people. So
Thank you. I appreciate
right
that.
now, there is no wiggle room.
Okay,
Perfect.
thank you, I appreciate it.
Nothing else to say.
Just great.
All right, make a motion to close the public hearing.
I'll make a motion to close the public hearing.
I did make the
Oh,
motion.
sorry. I'll second it.
Ms. Fryer?
Yes.
Mr. May?
Yes.
Mr. Ballard?
Yes.
Ms. Zielinski? Yes. Ms. Ruth?
Yes. What's your pleasure? What's your current manure removal situation? How do you manage your manure?
Consistent with what we said in November and what's in the manure management plan that's been in front of the board throughout the entirety of this review. Some of the manure is spread in the rear several acres of the property that will be behind that proposed arena. And some of the manure is kept in that manure storage
Right,
bay.
I'd like specifics
And
as
then-
to how often the
Yep,
manure bay is
no
empty.
longer than 1 year will the manure ever be stored on the property. That's consistent with the Ag and Markets guidelines. And then also, approximately every 3 months, remind me of the contractor's name? The Hannans, who were here at the last hearing, come in and cart the manure out as needed.
Is there record keeping for all this?
It's in the manure management plan that's in front of the board.
Is the record keeping done by the Fishers for this?
Certainly, and invoices and receipts consistent with the farm operations ordinary business practices. I'd also point to the information we put in the record back in the fall and in January in connection with the fact that we looked at the DEC mapper for wells in relationship to the property. There's no wells within 200 feet of the property. That's consistent with DEC guidelines for manure storage. So there's no health and safety concern right now with respect to how that manure is stored based on compliance with Ag and Markets guidelines and the manure management plan that's in front of the board.
Lauren, because one of the variances has to do with the location of the manure bay, would the applicant be willing to agree to a condition wherein they would certify annually regarding their compliance with the manure management plan?
I think that we could certainly work with a condition that requires regular demonstration that we're meeting the rules of the manure management plan. It's consistent with the Ag and Markets guidelines. And also with respect to the location of the manure bay specifically, and also that garage building that's right next to it, we're asking for reductions to the side yard setback, mostly to the north lot line. It's about, those items are about 12 feet away from the north lot line. That northern lot is owned by a gentleman named Brett Colling. He owns the other chunk of this parcel that used to be the old dairy parcel. He supports the farm operation and in fact supports the issuance of these variances. So the property owner that's going to be most impacted by that manure reduction in that storage distance is fully supportive of these requests.
For so long as he's the owner, someone else can buy it.
Correct, that's right, that's right.
So just to be clear, would the applicant consent to a condition of, if the board decides to approve, of annual reporting on compliance with the manure management plan?
Yes.
Great.
All right, I'd like to make a motion.
On the question, before you make the motion, if I could.
Please.
So, just so everyone is clear, the balancing test in Town Law 267B3B still applies. You're still required to evaluate benefit to the applicant as weighed against the detriment to health, safety, and general welfare of the public pursuant to the 5 criteria. But I want to just read from the letter that the town received from the Department of Ag and Markets, which said that provisions of state law require local governments to exercise their powers to enact local laws, ordinance, rules, and regulations that apply to farm operations in an agricultural district in a manner which does not unreasonably restrict or regulate farm operations, contraventions of the purposes of Article 25AA of the Agricultural and Markets Law, unless it can be shown that the public health and safety is threatened. That is the governor on the authority from the Ag and Markets Law. So, as you go through the factors, which I think is maybe what you're going to do next, in balancing the interest, just bear in mind the one caveat is unless it can be shown that public health or safety is threatened. So to the extent you believe locating these structures closer to the lot line somehow shows that the public health or safety is threatened, you'd want to explain why you believe that to be true as part of the record of your decision. So I just want you to keep that in the back of your mind. For the folks that were here that implored you to follow the laws of New York State, this is the law of New York State, which requires that the town cannot pose an unreasonable burden unless the health or safety is threatened. So there were talks about before and after, but this is actually what the law requires. So for all those people that were imploring you to apply the law, this is what the law of New York State is. So I just want you to keep that in mind as you go through the balancing test. Hopefully, you'll go through each factor, you'll explain how you believe the benefit outweighs the detriment for each factor, and to the extent you believe that public health or safety will be threatened, it's important for you to discuss that if, in fact, that's how you feel. I'm sorry for interrupting.
That's okay.
So you can either do them individually, or you can do them all as a group. It's totally up to you how you want to do it. You can do it as a block, or you can go through each one of the variances. The variances relate to the proximity of the manure bed, the equipment, the storage building,
Right.
and the stable building.
Which, I'm sorry, I've got a lot of papers up here. What is the variance for the manure bay? Is that the required 30 feet and it's actually 12 feet? Is that the right one? Do I have
Well,
it?
the manure bay and the stable building were under the 100-foot setback.
Oh.
They're also subject to the 30-foot setback.
Okay.
But because the 30-foot setback is subsumed by the 100-foot setback, they're just variances from the 100-foot.
Okay, where did you get that? Okay. I'm sorry, I just have one more question. There's no other way to move the manure bay a little bit? I mean, the variance you're requesting is 88 feet. I know that Ag and Markets says what they say, but 88 feet is substantial. Substantial.
The precise provision that requires that 100-foot setback is actually identified in the town's 2024 draft comprehensive plan as a specific provision in bold of the town's code that needs to be addressed because it has the tendency to interfere with farm operations. So particularly in this district, because this lot is 135 feet wide, I would point the board to the county DEP's comments to the board in response to the referral that Corey made. The county goes through a long set of factors. When they recommend that this board approves these area variances, they walk through the factors under the town's code. They walk through the factors that DEP likes to be concerned with in connection with these farm operations. So while you're evaluating the variance, and 88 feet ordinarily sounds like a very large departure, you want to think of it in the context of this Ag and Markets protection. You want to think of the Ag and Markets guidelines that say that typically we want to allow the development of farm parcels to be consistent with the development for other types of buildings in the area. So the more standard setback that applies to principal buildings and accessory buildings in this district is that 30-foot setback. So that's the setback that you're ordinarily looking at. That's what sets the general standard in the neighborhood. So though it's a large departure from that more stringent 100-foot requirement, it's still 12 feet from the property line, which in light of the neighborhood conditions, when you just drive down Lower East Hill Road or Cole or Omphallius in that general neighborhood, there are examples of other side lot lines that are similar to that.
With piles of manure on them? No. Every other horse owner in the town of Boston has to adhere to these guidelines.
The unique nature of this lot being 135 feet, even if you dropped that manure bay smack in the middle of it,
I know.
you would
It
still
don't fit.
require
Right.
a area
Oh,
variance.
There you got it, you said it right there.
Boom.
But
I would direct the board to DEP's comments. So that's the county body that's in charge of administering the ag program and gives the board recommendations from a countywide perspective on the application. So DEP suggests
Recommendations.
that in light of the uniquely narrow nature of this property, that 100-foot setback could be unreasonably restrictive in light of this
Understood.
particular
I'm
parcel.
not arguing for 100
So-
feet. I'd like 50, I'd like 30, I'd like more than 12. But there's no wiggle room apparently, and that,
We would be here before this board requesting a variance in either case. So we would be asking for it would be a change in a variance of approximately 30 feet. Forgive me for not being able to do the math off the top of my head, but if the manure bay is approximately 40 feet wide and you moved it off of the lot line to the center of the lot, we would still be here asking for a variance to
Okay,
both
okay.
directions.
That's what we're doing now.
Right.
We're negotiating.
we'd love to negotiate. Is there a way we can?
So particularly because the southern lots have been the most concerned with regard to the farm operations footprint, moving the manure bay away from that northern lot line would have a tendency to move it closer to the objecting neighbors. So that's just one point I would like to, from a practical perspective, while I see that the board is trying to work through
Would
an
you work with something on
analysis.
the south though, even though that's not part of it? Would you be willing to move the fence a little bit, even though it's not part of it? The fence there by the neighbors, would they, even though it's not part of it, would they give up some of that as opposed to the manure?
I think the manure pit belongs behind the arena.
The variance request before the board right now contemplates the current position. So we would ask the board to make a decision on that variance.
Lauren, as it relates to the manure bag, can you maybe help the board by walking them through the criteria for the area variance with specific reference to feasible alternatives? And also, as you well know, the zoning board is prohibited from granting a variance that is anything more than the minimum relief necessary. So I think it would be helpful for the board for you to explain the balancing of interest test with specific emphasis on feasible alternatives, and also explain why it is the minimum relief necessary to relieve your client's hardship.
So the five-factor test that Corey's referring to, I'm sure this board is painfully familiar with. So we're just balancing the interest between Horseshoe Hills' request to keep that manure bay sitting right where it is. So that's 12 feet away from the northern lot line, 88 feet away from the 98 feet away from the southern lot line. Am I getting that right? Okay. So with regard to how the farm operation functions, that's the location for the manure bay to allow the farm operation to function in its day-to-day basis. So that's the benefit to the applicant. It's very clear that they have a place for the manure that's in proximity to the stable building. It's in a location that allows trucking to come in and truck the manure out. So if we have an opportunity to evaluate whether or not there's a feasible alternative to move the manure bay to on the property where we wouldn't be required to seek that relief, that would be a feasible alternative. But in this case, because any movement of that manure bay would ultimately bring us back here to seek that relief, there's no resolution there. So the applicant doesn't get a benefit, nor does this board get a benefit. They're still asked to grant a variance. So whether or not it can be a shrunken variance by moving the manure bay to the center of the property. So what I would say is, right now, the detriment to the character of the area from having the manure bay sit right where it is very minimal. So that's based on the fact that it's more than 800 feet away from the road. Everyone's very familiar with this parcel here. So you're just pressed hundreds of feet off the road. There's no real visual impact for this manure bay except for principally that property to the north. So building on Jeff's point that he's been trying to be very neighborly as he lays out the footprint of this parcel, that location for the manure bay was chosen specifically because, like the chair mentioned, it should be behind the arena. Well, it went behind the garage building because it has a screening function from the front. And additionally, we are very keyed to the Woodrow's ongoing concerns with the impacts to their lot from this farm operation. So that manure bay, which is one of the offensive items from the Woodrow's perspective, is as far away from their lot as is possible in light of this parcel situation. So in order to get a reduced variance, we have to go closer to another lot line. So there simply is no feasible alternative where you're granting a smaller variance. To grant a smaller variance in one direction, you're granting a larger variance in the other direction.
Okay, but there's also a 30-foot side yard setback for all structures, right?
That's right.
So leaving aside the 100-foot, which we all acknowledge, you could not locate the manure bay on this 135-foot wide property and meet a 100-foot setback, but you could meet a 30-foot setback. So maybe you could explain to the board, how does the 30-foot setback create a hardship for your client?
If I could refer the board to maybe the printed materials that are in front of them that have a blow-up of the survey. Let you, maybe not, I can hand it all to you, I have copies. 2 points with moving it to comply with a 30-foot setback from that northern lot line. The first is you lose the lovely screening function of the garage because you move off of the same profile as the garage.
But you could move it to 30 feet.
You certainly could. You certainly could move it to 30 feet. But I don't see a benefit to the community, and it's certainly not a benefit to the applicant. So in terms of the balancing that the board is weighing, there's no benefit. There's not a benefit to the applicant, and there's actually a chance of ruining the important screening function the garage provides, because the manure bay is right now behind the garage. So from the road, the manure bay is not a visual item. But if you moved it to comply with a 30-foot setback from the northern lot line, you're now out from behind the garage and sort of in the gravel drive area. It would simply interfere with the existing features of this property. You would be moving right into the gravel driveway, the stable building itself. The manure bay is about 45 feet away from the existing stable building. There is simply not a location where you could keep the manure bay in proximity to the stable and move it 30 feet off of that lot line without pressing into the other existing buildings.
Are you suggesting that moving the manure bay out from the screening of the garage would be detrimental to your client?
Moving the manure bay would be detrimental to my client.
In what way?
The layout of the manure bay right now suits the farm operations function. It's in proximity to the stable building itself. It's situated so that the trucking can come in and pull the manure out. So moving the manure bay 30 feet off of the northern lot line would require reorientation of all of those existing features And it would change the access route for the planned trucking that's incorporated into the manure plan.
The survey, does that have all the buildings on it and everything? They're all plotted, they're all,
So this is a super zoomed out version of the entire parcel, and then a blown up, right behind it, there's a blown up version so that you can get a better look at the relevant 3 structures.
To our esteemed attorney, are we concerned with their convenience? Do we need to be, as far as our 5 criteria are concerned?
Not particularly, no. That's what I'm trying to understand. How does a 30-foot setback for a manure bay create a hardship for your client?
A 30-foot setback to the manure bay creates a hardship for the client because to move the manure bay into a location on the parcel where it could be set 30 feet off of the northern lot line would, 1, move the manure bay closer to neighbors that he has assiduously tried
But
to
that's
stay
neighbors,
far
right?
away.
I'm not asking about neighbors, I'm asking about their hardship.
Indeed, their hardship would simply be that the moving the manure bay so that it complied with the 30-foot setback would require complete reorientation of the existing farm operations setup. The existing stable building is about 45 feet away from that manure bay. So if you moved it 30 feet off the lot line, you're moving it into the actual stable yard itself, the functioning gravel drive. There's simply not a location where a 30-foot setback to the manure bay would work for the existing footprint of the farm.
Is it your position that there is no other location anywhere on this site where they could site a manure bay? This is the only location. Where it is located and 12 feet away is the only location on the entire property where a manure bay could be located.
That's right. Without the manure bay, there's also room to spread the manure in the back several acres. So the manure bay is one
For example,
component.
If the manure bay was 13 feet away instead of 12 feet away, that would not be feasible?
It's the movement, it's the
If there
physical.
were no manure bay there now, right?
Mhm.
Could you site a manure bay 13 feet away from the lot line? Or if, the only place on the entire site is 12 feet away from the lot line? Is it your position that that is the only location on the entire site where a manure bay could be located that would be feasible for your client? 13 feet wouldn't work?
13 feet wouldn't work because it would interfere with the existing footprint of the farm
So
operation.
1 foot, it's your position on the record that a 1 foot movement would interfere, that your client would not receive any benefit from the variance. That's your position?
Indeed, in order to receive the benefit that it's asking for, which is the manure bay in its current location, a 1 foot move, or any foot move, would
not
be
provide-
infeasible for the farm operation.
How so?
In light of the existing layout of the property, which relies on the gravel drive to provide access to
So
the manure
1 foot
bay,
is gonna make it completely infeasible.
a 1 foot relocation of the manure bay would be infeasible.
I feel like there's plenty of space on it.
Did you have something else?
only if you want to hear from me.
So just a reminder to the board that section 267B3 267B2C says that in granting, sorry, 267B3C says the Board of Appeals in granting area variances shall grant the minimum variance that it shall be necessary and adequate, and at the same time preserve and protect the character of the neighborhood and health, safety, and welfare of the community. So they have explained to you what they believe to be the hardship that is created by locating the manure bin. But you are limited to only grant the minimum variance necessary while preserving the character of the neighborhood and the health, safety, and general welfare. So keep that in mind as we deliberate. They are asking you for an 88-foot variance from that requirement.
Oh, man, what did I volunteer for back in the day? Oh, my goodness. All
Are
right.
you going to take them individually, or are you going to take them as a block? Individually.
I guess I will address each one in one motion, I guess. So I would like to make a motion. What petition number is this? Thank you very much. For petition 635, I'd like to make a motion to approve the setback variances for, well, this is variance, I don't know. Okay, so the first setback, I'd like to approve a 70-foot setback. The south side would be a 2-foot setback, I'll approve that. The north side, I'll approve a 30.6-foot setback. And then a south side, another one 72.21 foot setback in accordance with our compliance for the zone with our town code, I guess. And then, as per our conversation earlier tonight, the stipulation was agreed to by the applicant that they would annually report of the manure management. I'll read through our conditions here. Does it create an undesirable change to the character of the neighborhood? Yes. Can the benefits sought by the applicant be achieved if the variance is not granted? No. Is the requested variance substantial? The one that I approved is not. Will the variance have an adverse effect on the physical impact or environmental conditions of the neighborhood? Yes. Is the alleged difficulty self-created? Yes.
So I just want to be clear about which building were you talking about?
So the north side, Manure Bay,
You're just talking about the manure bay.
that I approved,
You're making a motion to approve
yes, for a 70-foot variance.
so for the north side, they asked for 88 feet. You are making a motion to approve a 70-foot variance.
Yes.
Bringing it in line with the 30-foot that the town code has currently.
Bringing it in line with the 30-foot side yard
Yes.
setback requirement that's generally applicable to all structures.
Yes,
Correct.
yes.
Okay. And you believe the benefit to the applicant of granting a 70-foot variance outweighs the detriment to the health, safety, or general welfare?
Yes.
And can you read again the first factor?
Does it create an undesirable change the character of the neighborhood?
So having the manure bay is required to be 100 feet from the lot line, having it 30 feet from the lot line, you think will create a detriment, will negatively impact the character of the neighborhood, be a detriment to nearby property?
Okay.
Why?
With it 30 feet off of the line, so a 70-foot variance, I'd like to amend and say that no, it does not create an undesirable change to the neighborhood.
Because it is in line with the 30-foot side yard setback generally applicable to other structures?
Yes, precisely. I'd like to call for a...
Hold on, let's go through each of the factors. Whether the benefit sought by the applicant can be achieved by some other method feasible for the applicant to pursue. Do you believe that they have other feasible alternatives than locating it at 30 feet off the lot line, or that there are no other feasible alternatives for them to pursue?
Can you rephrase that?
Sure. Are there feasible alternatives for them to pursue other than having it 30 feet off of the side lot line? If you think there are no feasible alternatives for them to pursue, that having it 30-foot lot line, for example, 40 feet or 10 feet, right? If there are no feasible alternatives for them to pursue, or you can say that there are feasible alternatives, that they could put it somewhere else totally on the lot, but you find that's the minimum variance necessary, and so 30 feet is.
I think that they could put it 50 feet off the line, but 30 feet seems to be, that is the minimum variance that I'm willing to grant, and it because it stays in line with our compliance and our town code.
Okay. Is the variance substantial, having it at 30 feet where 100 feet is required? Or is it not substantial because it's then in line with all other structures?
Yes, no, it is not substantial because it is in line with the 30-foot compliance.
Will it have an adverse effect or impact on physical and environmental conditions in the neighborhood?
Not with the 30 feet.
And was the difficulty self-created?
Yes.
Okay. And so, what is your motion? You're moving to approve. You're suggesting that you've undertaken the balancing of interest test, you've weighed the criteria, and you're determining that the benefit to the applicant outweighs the detriment to health, safety, or general welfare for a 70-foot variance.
Yes. Yes.
Is there a second?
I'll second.
Ms. Pryor?
Yes.
Mr. May?
Yes.
Mr. Ballard?
Yes.
Ms. Zielinski? Yes. Ms. Rude?
Yes.
Approved.
And then you're gonna take the other ones as a block, the other,
I think there's still a pending variance in connection with the manure bay itself. There was a variance request.
here, come up to the microphone,
Oh, I'm
give your
sorry.
name for the record.
Lauren Arenado, Phillips Lytle for the applicant. There were 2 variance requests in connection with manure bay because of course the 100-foot lot line setback requires both to the north and to the south. So to the extent that you've approved a variance for the northern lot line, you would have to do the same analysis for the southern lot line. And of course, we are requesting a 2-foot variance.
That was approved.
Just for building.
That was the 70-foot variance to the northern lot line, but there would be 2 variances for the 100-foot setback in connection with Manure Bay, because it's a 100-foot setback to the R lot line to the north and a 100-foot setback to the R lot line to the south,
Right.
which is the nature of the request to keep the Manure Bay in the same place, is that in order to shrink the variance to the north, you magnify it to the south.
No, understood. Did I get the numbers wrong? I must have gotten the numbers wrong, no? I don't know. So I'll, yeah, I do. So. I approved that one for 7. So I'll take the 18 that I didn't do here and I'll add it to this, so it's a 20-foot. No, I need 20. Okay. Right. Right, instead of 2. Okay. So, to be clear, I'd like to, yeah, all right, we'll do this again then. The required setback on the north end is 100 feet. Because of our code, setback, compliance, all that stuff we've already gone over, I would like to approve that for 70 feet, which then, as our attorney pointed out, I have to add 18 feet to the south side where it's required 100 foot. And now the, instead of having a 2-foot actual variance requested, it would be 20 feet requested, which I would still approve. I'll make a motion to approve. Does that make sense?
That's not the variance that we're requesting. We're requesting that the location that the Manure Bay is currently in. So to the extent that
We
the,
want to move the Manure Bay.
It's 30 feet off the line.
30 feet off the line, and then obviously it'll be 18 feet closer that way.
it'll be 18.
Because the state law says that we should do the minimal
Just review the
variance.
map.
I think your intent is to improve a reciprocal variance on the south lot line in conjunction with the variance that was approved for the north lot.
Yes, yes,
Does that make sense,
precisely.
Lauren?
You got a second. And I think we all did the vote.
For all the same reasons that you gave for the north lot line.
Yes.
So why don't we call the roll again on the south lot line?
Ms. Pryor?
Yes.
Mr. May?
Yes.
Mr. Ballard?
Yes.
Ms. Zielinski? Yes. Ms. Ruth?
Yes.
So what's the difference?
I'll have to make the math, I don't know. Whatever reciprocal variance is necessary for the Manure Bay to
We're
be
asking for
30
2
feet from the north lot
on
line.
the south.
It's just more.
Oh, okay.
Does that make sense?
Yes, thank you.
Yeah, 30, it's gonna be 30 feet off the north.
How long do they have for their variance? Or their approval, their particular, it's like 6 months or something to get things going? Is that how it works?
Reasonable timeframe.
Reasonable timeframe. Okay.
Well, we should put something on it, because that way they have to move that pit, like, what would they have on moving that?
Let's say 3 to 6 months.
I'll check the code. I don't have internet access here.
But we want an actual, like, we want to lock a date on that, so it's done by them, or
Yes.
they
And they're
receive
gonna be
penalties.
construction up there too, so
Okay.
that may hinder the timeframe a little, but I would say by October, 3 to 6 months. max.
Okay, October 1st.
Well, I don't understand what the question is.
Are all the variances covered now?
I struggled to follow your original motion. I followed the motion on the Manure Bay. You were also making a motion to approve the other variances as requested, correct?
Yes.
And you are doing so, well, why don't you make a motion to do that, just so that we're clear? Just make a motion to.
I want it to be clear.
Yeah, make a motion to approve the remaining variances as requested.
Okay, I'll make make a motion then to, outside of the maneuver bay, approve the variances, the requested variances as they stand.
Because the benefit to the applicant outweighs the detriment to health, safety, and general welfare.
Because the benefit to the applicant outweighs the health benefit of the.
Let's quickly go through the factors again,
Thank
whether
you.
good desirable change to reduce the character of the neighborhood or detriment to nearby properties.
No,
Why not?
because they're not, manure bay, there's no flies, they're feet off the line.
The
there's-
equipment, the storage buildings, and the stable building,
They don't impact the character of the neighborhood.
whether benefits sought by the applicant can be achieved by some other method feasible to the applicant to pursue.
No,
Whether the requested area variances are substantial.
not in this case, no.
Whether the proposed variance will have an adverse effect or impact on physical and environmental conditions.
No,
And whether the alleged difficulty was self-created.
no. Yes? What did I say for the last one? Yes.
Does anyone want to expand upon any of those factors about why the benefit to the applicant outweighs the detriment to health, safety, or general welfare? Specific to the location of the storage building and the stable building.
I feel like in accordance with other petitions that we've had before us, sheds, people wanting to put things up, it's not something that I typically am concerned about as far as impact on the neighborhood. So I don't feel it's, they agree with it.
Did you put it in?
Okay, I'd like to add more to the motion.
Well, let's hang on a second.
These are the stipulations.
This is on the building permit.
Yeah.
So we're good with those. Yeah. Yep, those are conditions.
Those
of the
are?
building permit, yep. So there was a motion, did we have a second on your motion? I don't remember, sorry.
I'll second.
Was there already a second?
There was, probably.
Okay, there's already a second. So will we call the question? We don't call the roll, you did, you called the roll on the second one, the last one?
Let's do it one more time.
Great.
Okay. Ms. Pryor?
Yes.
Mr. May?
Yes.
Mr. Baylor?
Yes.
Ms. Zelinski? Yes. Ms. Ruth?
Yes.
Okay, so this takes care of the other two that were being approved as is.
Yes, correct.
All right, congratulations, your variances are approved.
I make a motion to close this meeting.
To adjourn?
Ms. Pryor?
Yes.
Mr. May?
Yes.
Mr. Baylor?
Yes.
Ms. Zelinski? Yes. Ms. Ruth?
Yes.
We have to sign.
Sign the sign.